In this video, I'm going to show you a simple demonstrative that you can make or actually even draw during the course of your next trial that's going to effectively undermine a classic argument by the defense that your client's injuries were not actually caused by the event in question. So let's start with what the problem is. The problem is you get the trial and you have a clear-cut liability case. Sometimes maybe the defendant as a strategy has admitted negligence under the circumstances. So the only hurdles you have to overcome is causation and then the extent of damages. And the problem is that you get into trial and the defense has hired medical experts, or they have just simply cherry-picked things out of the records, or they've cherry-picked statements out of deposition testimony and try to subtly suggest to the jury that maybe your client's injuries aren't caused at all or aren't caused entirely by the event, the negligence of the defendant, like you say they are. How does this hurt your case? Well, it can hurt your case in two different ways. One, if they can make a compelling enough argument, it could cause the jury to check no on causation.
No.
And you lose, and your client gets 0 in the verdict.
0.0.
But number two, and what I see happen more frequently, is that it plants the seeds of doubt in some of the jurors' minds, and it undermines the credibility of your claim, of you, the lawyer, and the plaintiff, the innocent injured person, as far as their claims in general, and sort of suggests or can make it look to the jury like your client is overreaching, which then taps into a lot of those preconceived notions that a lot of the tort reform thinking jurors have out there, that plaintiffs are just out for a money grab and plaintiff lawyers are out there to help them do that, and they don't want to be taken advantage of. At the end of the day, everybody wants to do their job for the right reason. Jurors are no different, and they don't want to feel like they were taken advantage of. And this argument that, oh, maybe it was this pre-existing condition, maybe it was this unrelated event that happened after the incident in question that contributed to this. Maybe it was your client's age. Maybe it was anything else but the event in question that caused or contributed to the harm. That starts to chip into your credibility, your client's credibility, and can lead to a much lower verdict, a verdict that is less than full and fair compensation. Why do the defense lawyers do this in our cases? They do this because they're instructed to do it by insurance companies, or they've been instructed so many times by the insurance companies to work this argument subtly into the case that they do it naturally. It's point fingers elsewhere. It's throw spaghetti against the wall because they've got nothing to lose. It's only to their benefit if they can get some jurors doubting the extent of the injuries that were actually caused by the event in question. That's always going to help them. That's either going to lead to no verdict or a lower verdict than what should actually be entered under the circumstances. So what is the solution? Well, the solution is manifold. Number one, I would recommend you take a read or listen to the Brushstrokes podcasts of attorney Keith Mitnick, who talks about a concept of common sense versus coincidence. And that actually dovetails nicely with the demonstrative I'm going to show you in just a minute. But what attorney Mitnick talks about is pointing out to the jury through witnesses, through opening statements, that they are going to see that there was a clear event that changed the circumstances of your client's life. And it's going to be up to them to think to themselves and to really consider, was it just a coincidence that all of these injuries, all of these deficits developed at the time or shortly after this event? Or should they use common sense? Okay, should they use their own common sense that, hey, wait a second, it wasn't some other explanation. It wasn't some unknown factor out there that suddenly caused all of these injuries to occur. It was the event in question. It was the negligence of the defendant under the circumstances. And there are some really clever ways and effective ways that you can examine witnesses to really pull this out so the jury can see the truth of the situation. But I think that's not enough. And visually, you need to make the point to the jury because obviously a visual, a picture is worth 1,000 words. So what I'm going to show you in just a minute, I have used effectively in trials. We used it effectively recently in a good concussion verdict that we got in a rear-end motor collision case. And anecdotally, a couple of the jurors specifically told me that this demonstrative was effective in making the point to them.
It works. It works.
So I do have some evidence to think that it could be effective for you to use as well. It's very simple and easy to either draw or put together. So let's take a look at what I used in this particular case. Okay, so you can do this demonstrative two ways. You can get a big drawing pad and you can draw it out at the time, which I actually think if you can do it right is really effective because it sort of unfolds and helps the jury kind of see the pieces in the parts that they should be rather than all at once. But if you do the PowerPoint slide like I do, I recommend that you use animation to have the pieces come out in chunks. So here's the demonstrative and how it works. So keep in mind the most recent case that I used this in was a rear end crash. And in the days and weeks afterwards starts to develop symptoms of a concussion, symptoms of an inner ear injury, but it takes some time for them to unfold. But she had never had these deficits or injuries before the crash. And our client happened to be 77 years old at the time, so we started with the following. So first you put up this line that represents essentially their whole life. 77 years, they had been going along in good health, working, active, no problems whatsoever, none of the deficits whatsoever. I'll click to the next part. It shows the crash. Mr. Trombola was the defendant in this particular incident. So now you have this stark change. I do red, sort of suggesting warning, bad, etc., and that pops out. And now you click to the final portion of the slide, which is everything that developed afterwards: headaches, dizziness, fatigue, brain fog, 100+ physical therapy appointments, and so forth. And the point being that there's this stark change. It was everything was good, and then suddenly everything is bad. And what changed? What changed was the crash. The crash was the cause. You can use that slide also if your client had pre-existing injuries. And so what you do is you just add a section at the beginning. You indicate and be upfront with the fact that the person, let's say they had a bad back, a lower back or a neck injury, but that they recovered from it and were mostly symptom-free. Or again, maybe they weren't. Maybe they had some symptoms, but as a result of the injuries from the crash, they have new symptoms. And so you lay that out and you show that they were not having the symptoms or the deficits or the problems that they're dealing with as a result of the negligent event. And then you clearly show how all of that started afterwards. And that really capitalizes on the jurors' common sense. They see that visually. It makes sense. Obviously, what changed? What changed was this event. And it sort of simplifies everything for the jury to now be more receptive to the different medical evidence and testimony that they're going to hear over the course of the trial. Because I really do believe that it makes the point that it was this crash and it wasn't some random other event. And that's going to help you get over that causation hurdle at trial. It's going to be more likely that the jury is going to check yes to causation, and it's going to be more likely that the jury is going to award your client fair and full compensation for their injuries that were caused through no fault of their own. I hope it helps you. I hope it helps your client. If you want that slide, please feel free to reach out to me via email and I'll send it to you. Thanks for watching.